I heard you saying wonderful things about GAAR, so I guess I'm good. I got a little bit of work to do here. So yeah, okay. So, all right. So here's my well, what are we talking about? We're talking about abuse and planning, and I guess it's on a spectrum somewhere between evasion and just like compliance. So I just could start with that idea, I suppose. I think that what's interesting for me is to start kind of where Yaru started, which is, just to be sure everybody's clear about our system. We have a federal system. The Constitution gives exclusive legislative authority to our Parliament, extending to all matters coming within the classes of subjects enumerated. And then, of course, one of them, the raising of money by any mode or system of taxation. So we always start with this idea that, countries have a right to tax. They don't. They claim a power to tax. It's an authority. It's an explanation of authority, not something inherent in nature. And in our federal system, that means that we do leave some power to the provinces. Each province can exclusively make laws in relation to matters coming within the classes of subjects. All these words to say, provinces, you can tax things in your territories, but it has to be direct taxation, or you can tax these things, shops, saloons, taverns, auctioneers, and other licenses. And why it has to be in order to the raising of a revenue for provincial, local, or municipal purposes. So, okay, fine. And this is like a standard federal system. I think Brazil has a federal system also, and so we can compare our constitutional language and see is there sort of a carving out of a base here and there, just a background. And then, I wanted to do one more thing just to give you that you can find Canadian tax law kind of all over the internet. And in my PowerPoint, I have hyperlinks, which obviously doesn't help you unless I share my PowerPoint with you. But just so you know, you can find the Constitution Act, the Income Tax Act, our conventions. We do have some regulations, and and then the court cases. You can find them all online. And if any of you really wanted the hyperlinks for some reason, Google did not cooperate with you and didn't give you the links, let me know. I'm happy to share these. So I'm going to start this idea about abuse and planning from the general and then get more specific. Depending on how much time we have, we'll get to cases, but it's possible we just have to look at this at the highest level. And please do just interrupt. If you have a question. I'm going to try to keep my eye on the on the chat or whatever, and on the hands. But just go ahead and jump in if you're not following what I'm saying. So here's the general standard: large and liberal. I don't know what large interpretation means. I've never understood this term large. To me, large is like a physical thing, but this is our language, and we have this constitutional interpretation must concurrently evolve with the changing realities of Canadian society as encapsulated by the so-called living tree doctrine. Okay, and what is that doctrine? Well, here it is. It says this is from a 1930 case. It says the British North America Act, which is a colonial act, planted in Canada a living tree capable of growth and expansion. Their lordships do not conceive it to be the duty of this board to cut down the provisions of the act by a narrow and technical construction, but rather to give it a large and liberal interpretation. Now, if you like the living tree language and you want to revisit it, you can go to my TikTok page. I have a living tree quote in the TikTok, so you can always go back and read it to yourself or listen to, I don't know if it's me or my student, one of us giving this one. I think this one I did. Okay, so that sounds good, right? That sounds like words have a lot of meanings and they're contextual and the context changes, and we should take any kind of statutory language and read them that way, right? Well, not so fast. Not so fast. Because when it comes to tax, we kind of have the opposite view, which is that we should have a literal and strict, not to say formal interpretation. And I'm sure you're all familiar with this. You have this textual or black letter approach. And why on earth, when the Constitution is a living tree doctrine and we're like living and growing and evolving, why are we totally conservative, small c, conservative, when it comes to tax? Well, there is a really good reason for this. The really good reason is that there's a traditional view about tax. And there's an idea in the common law, our mother country, England, that statutes were an exception to jurisprudential law, and that tax laws in particular were viewed in the same way as criminal expropriation laws. I mean, and you can kind of understand this. If the Constitution tells you that you have a right to property and you have a right to be rewarded for your labor, that you can't have, you can't be underpaid or coerced into labor, then how can the state tax you? It feels like the state is taking your labor or taking your property. And so, we really have to explain this somehow. And so this traditional view where tax laws are viewed as equivalent to criminal expropriation laws, then they have to be explained clearly. And it has to have the only one purpose, and the only one purpose is to raise revenue. And so the lawyers have to say what they mean. The people who write the statutes have to say what they exactly are going to take from you when they expropriate money from you. They have to say exactly how much in order for it to be legitimate. But this popularity of this approach has changed over time. So this is a traditional view, and here's a quote from an 1869 case. And I think this captures a lot of the conservative view of taxation. You often see some iteration of this idea. If the person comes within the letter of the law, they must be taxed, however great the hardship may appear. On the other hand, if the Crown cannot bring the subject within the letter of the law, the subject is free. However, apparently within the spirit of the law, the case might otherwise appear to be. So the point is, law has to catch you. If the tax law doesn't catch you, it doesn't catch you. That's not avoidance. That's not abuse. That's not anything. It's just the law not catching you. This is this traditional view. Well, today we have this kind of mix-mash mess, really, of a modern contextual approach to interpretation. So we're going to take that textual, literary, or literal, conservative interpretation, and that broad living tree, growing, evolving thing, and smush them together. And we're going to do text, context, and purpose. So we're going to start with the plain or the ordinary meaning, sometimes called the common sense meaning of words. And we're going to consider the lawmaker's intent in determining purpose. Okay, I said it's messy, so here comes the mess. Okay, so here comes a case in 1984 that tries to do this text, context, purpose thing. And the case says, well, the words of the the Income Tax Act, are to be read in their entire context and in their grammatical and ordinary. You see the denial of context here. Grammatical and ordinary. Well, who's ordinary? What is ordinary? But this is the text. Harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. Okay, lots of fancy, wonderful words here. That's Stubart, 1984. But just be careful, this is not an economic substance rule. In the Bronfman Trust case in 1987, the court actually went in that direction, saying, well, we're doing an economic substance thing here, right? That's what we're doing, right? But other courts and other cases were a little bit not so sure about that. So in response to this 1984 case of Stubart and these inconsistent cases, including Bronfman Trust, that seem to mess it up or not quite get it straight, that's what brought us Canada's GAAR in 1988. Now, I was not even in law school yet in 1988, so I'm just telling you ancient history here. This is all when I was, in high school and stuff, well, college maybe, but, this is a long time ago. To me, this is ages ago, but we're still fighting about what they adopted. We're still arguing about what did we say. So they adopt this GAAR. We're going to look at the GAAR in a minute, but the cases just go back and forth. They just default back to literal and strict interpretation. They use context and purpose, yes, but only when they see ambiguity. But ambiguity is in the eye of the beholder. I'm sure you know that from looking at cases, that you don't know ambiguity until somebody tells you it's ambiguous. Then you say, oh yeah, sure, ambiguous, yes, definitely. And then you start looking at context and purpose. So we've seen a lot of examples of cases just doing this literal and strict interpretation and not at all thinking about living trees or any of that stuff. And we see them especially in interest deductibility cases. Shell and Singleton are two examples, but just an extremely formalist view of interest and really just accepting what you might consider to be egregious avoidance, if not abuse. Just no discussion about abuse because the words of the statute were literal, plain, grammatical, ordinary, common sense words that had to be interpreted as such. And this let the taxpayer get away with a lot, rich taxpayers get away with a lot. So in 2005, we get this Canada Trustco mortgage and the Supreme Court reiterating, okay, you do need them all. You need text, you need context, and you need purpose. You need to work, you do the whole thing. You need to find a meaning that is harmonious with the act as a whole. But they do say in Canada Trust Co. that the plain meaning dominates context and purpose. So what does that mean? Like, what's the future for us in our interpretive approach? To me, just like I did on my slide here, it's just a mess of stuff that doesn't seem to like give us a perfect answer, but we just have to go back and forth between these ways of seeing and viewing. All right, so let's take a look at our GAAR. We're very wordy in Canada, I find, in our statutes. I don't know if you feel the same about Brazil lawmakers. Do they like to use a lot of words where just a few you think might do? But we like a lot of words. So here's our basic rule, the ITA being the Income Tax Act, Section 245. Where a transaction, so we have the transaction oriented, where a transaction is an avoidance transaction, the tax consequences to a person shall be determined as is reasonable in the circumstances in order to deny a tax benefit. And there's like a whole lot more words, but we always get the same summary. I see the same summary wherever I look, like in commentary, court cases, they always say the same thing. There's three elements. So we just need all three, though. You have to have all three. If any one of them you don't have, it's not GAARable, as they say. So the first one is the taxpayer has to enjoy a tax benefit, like have to enjoy a benefit. You have to feel some sense of enjoyment, I don't know, but you have to enjoy a benefit. They have to get a benefit. So we're going to care a lot about what benefit means. We're going to have to define that. And then the taxpayer engaged in an avoidance transaction. Well, you need a transaction and the taxpayer engaging, so you already have a problem with the taxpayer has to be engaging in the avoidance tax transaction. So if it's somebody else, some other taxpayer is engaging in something, you might have some trouble there. But it has to be an avoidance transaction. So we have to define enjoyment of a tax benefit and avoidance. But even there, the taxpayer can say, oh yeah, I had a benefit. It was great. I was really enjoying it. And they can say, and I was doing it by avoiding. Look at me. I was avoiding and I'm enjoying my avoidance by having a benefit. But you still don't have GAAR unless the avoidance was so-called abusive tax avoidance. So now we see this word abuse. It's in the Canadian GAAR doctrine. It's not enough to avoid. You have to have abusive avoidance. So you see a lot of the cases, the taxpayer will admit to enjoying a benefit and the taxpayer will admit to avoidance. There's no problem. They're just, all day long avoiding and enjoying benefits. And where the government gets in trouble is they have to prove abuse. So, well, how do you prove abuse? I can't watch you take the act and beat it with a stick. You have to somehow come up with some explanation about what abuse means. So we adopted this GAAR at the federal level. Remember, we have provinces, and I happen to live in the province that likes to do what the federal government does the least. So if there's somewhere the government does X, Quebec will often say, well, why not Y? But in this case, province of Quebec adopted a similar provision 2 years later, and we have that here on the slide. But it doesn't sort of matter what you adopt, because what is a GAAR? It's a giving up on the part of the lawmaker. They can't make the law say what they mean. They can't make it cover everything they want. So they just say, okay, well, judges, now it's your baby. You go figure it out. We give up. We can't find enough words. We have put all the words in we can think of, but still the taxpayer is wily. Still the taxpayer gets away from us. So you guys have to catch the taxpayer. You catch the naughty taxpayer with our happy, fancy little statute here. So, okay, fine. when Yarif talked about the U.S. not having a GAAR, it's true, but the U.S. has economic substance, and they have a number of rules that just simply delegate the responsibility to catch the taxpayer to the judge. It's exactly the same thing. That's what GAAR does. It's just delegating the responsibility to catch the taxpayer to judges. Now, obviously, taxpayers love and also pretend to hate GAAR. They love GAAR because as long as the law is unclear, then you could be GAARable, but you might not be. There's some room to maneuver. But they say they hate GAAR because they say, oh, it's so uncertain. I don't know what's going to happen. Judges can do anything. They can flip the whole income tax system upside down and rain extra duties on my head, which they never seem to do. They never do that. What actually has happened in practice is that judges have been like, ooh, GAAR. Yeah, I get it. I hear what you're saying, but I don't really feel comfortable here because I'm not, super happy about being the person that is going to tell you that the tax law says something different than what you, the taxpayer, want. And it just is kind of a bit of a mess. So, all right, let's just for fun. Let's compare the UK's GAAR, because remember, we are just a colony of the mothership, and the mothership is the UK. So I think you guys know that feeling. You understand where that comes from. Some little country in some other place whose law apparently really matters to your law. I can relate. So here's the UK GAAR. It says their GAAR applies to tax arrangements, so not transactions but arrangements. Is that a different thing? Is a transaction and arrangement the same? I don't know. So are we going to use UK cases when we interpret our GAAR? They say arrangements, ours say transactions. Oh dear, that's two different words. And they have to be abusive. Okay, and they say, but they give us an explanation of arrangements. Arrangements are tax arrangements if, having regard to all the circumstances, it would be reasonable to conclude that the obtaining of a tax advantage was see the word the main purpose, or one of the main purposes. Okay, so you see how lawmakers love to, they couldn't just say one of the main, they had to say the main purpose or one of the main. I think that we could edit just slightly a few words out of this and it wouldn't change anything, but I'm not in charge, obviously, of the arrangements. Okay, and they say, and here's their abuse definition. We don't have this definition. Tax arrangements are abusive if they are arrangements, the entering into or carrying out of, which cannot reasonably be regarded as a reasonable course of action in relation to the relevant tax provisions, having regard to all the circumstances. Like, sort of looks like our GAAR. I mean, it's got some of the same words. They're just mixed in a different direction. Like they took we took their GAAR and put it in a smoothie and put it in a blender and whipped it around and then spit it out, and then it was basically the same but not quite. And then you get some guidance from, I think it's Her Majesty's Revenue something. I can never remember what the C is. Anyway, Her Majesty tells us, the Queen herself tells us that the primary policy objective of the GAAR is to deter taxpayers from entering into abusive arrangements, and look at this part, and to deter would-be promoters from promoting such arrangements. So tax lawyers, beware. You are the subject of GAAR. There may be tax avoidance arrangements that are challenged by HMRC using other parts of the tax code. Okay, so they don't close any other options off. But if they're not abusive, they're not within the scope of GAAR. So abuse. That's the thread here. We got to have abuse. And then, let's just see. We all have treaties with each other. We have a treaty with Brazil. We're not like the U.S. We don't have a bad, a grudge against what happened in the 50s or something and say no treaties ever. So we have treaties. We have treaties together. Brazil and Canada do. So we have to look to see treaty interpretation. And I'm sure you know this from your practice, that a treaty is to be interpreted in good faith in accordance with the ordinary meaning. So denying culture, denying history, it's just the ordinary meaning, it's in there somewhere. We have to decide what we make of those things about changes in who we are as a human species, right? And how language has context, or language is contextual. Okay, so ordinary meanings of their terms in their context. So text, a treaty shall be interpreted in accordance with the ordinary meaning of terms, that's text, in their context, and in the light of its object and purpose. So Canada's text, context, purpose thing seems to be, just standard, nothing new to see here, very standard. And then you get this OECD commentary. I'm sure you've read this at some point in your careers. If you haven't read the OECD model commentary, I suggest you run right out and start reading it. It's lots of fun. There's all kinds of stuff in there that might surprise you. But here you go. OECD commentary tells you abusive transactions, I think they use the word transactions, may be rejected due to domestic GAARs or because they violate the object and purpose of the treaty. So we see some tying of these concepts together. And then we have this Queen versus MLI Investments. I think that's a Société Anonyme, so it's like a French, so it's like might be Quebec. I don't know where the company was or incorporated, but anyway, they're using that French corporation term there. And they say in this case that the purpose is informed by the treaty's text and context. So this is all feeling like, okay, yep, I get it. Text, context, purpose. Alta Energy more recently pulls back on that again, coming back to a literal or strict or small c conservative, really trying to pull back on this idea that we're going to be expansively interpreting things all over the place like living trees that could just go anywhere. We don't want to do that, so we have to stick to the text if we can. And you get this notion that a treaty text may be construed as conclusive because it is consistent with and fully explains its underlying rationale. Well, I don't know if you've read any treaties lately, but it is true that treaties have got longer over the years. Did you know that when we started doing tax treaties 100 years ago, it was thought that treaties were kind of almost like a handshake agreement, like you put general terms out there, and everybody was kind of like lovey-dovey on good faith interpretation terms with each other, so nobody would, try to go too far with their treaties or do something, devious with their treaty interpretation. And also you didn't want to make them too specific because then taxpayers, would feel like they were, planning with tax treaties, and, who would do that? So that was the idea. And over time, I think those people that thought treaties were diplomatic instruments that were nicely nice handshakes and good faith agreements, actually know they were instruments for taxpayers to comply with. And so they had to get tighter and tighter and longer and had more and more words. And now some of the treaties are, just a lot more complicated than they used to be. But if you want some, to see what a treaty used to look like before we didn't trust each other when we were doing treaty arrangements, go look at the U.S. treaty with Hungary. You can drive a truck through that treaty. Every investment in Canada should be done through that, through the Canadian treaty with Hungary, because the U.S. treaty with Canada, U.S. has a treaty with Canada, and the U.S. treaty with Hungary has no limitation on benefits provision. You can treaty shop all day long with that treaty, and people do. So, this is sort of a little bit of a divergence from our focus on the domestic GAAR and domestic abuse. But the point is, what is abuse? Well, I don't think that they didn't have tax abusers 100 years ago. I think that they didn't think that treaties were the place to solve those problems somehow, or didn't really anticipate just exactly how much difficulty they would have in getting treaties to work over time. And, here we are, tax lawyers learning about treaties, interpretation, and abuse. All right. So fine, we got all these treaty terms, but does our domestic 245 GAAR apply to treaties? Well, an early case said, well, why not? Like in 1988, the GAAR statute was very simple. It had those three elements, and it didn't say anything about treaties. And so an early court, the court was called RMM Canadian Enterprises, Inc., and others versus the Queen, is, of course, all of our cases are also against the Queen. Remember, colonial, blah, blah. So we're always fighting with the Queen, or always having controversies with the Queen when it comes to taxes. It's all her money. And this case said, well, why not? And, it says to interpret everything, according to this tax abuse theory. But there was some disagreement. People were not so sure about that. And some courts said, no, why would you apply GAAR to treaty? GAAR is about statutes, statutory interpretation. So they did an amendment in 2005. They added the treaty, they just added the word. They just said GAAR applies. GAAR applies to a transaction only if it may be reasonably considered that transaction would, if this act were read without reference to the section, result directly or indirectly in a misuse of the provisions of a tax treaty. So they just put the words in there because the courts were being inconsistent, or people weren't sure if GAAR should apply. And then they have this Income Tax Conventions Interpretation Act, and they say the same thing. Yes, Section 245 of the Income Tax Act applies to any benefit provided under the convention. So that takes this idea of tax benefit and moves it right over to the treaty, because everybody, you all know this. The whole point and only point of a tax treaty from the investment side of things is to give taxpayers benefits. So you're always going to have a tax benefit when you have a treaty. If you're a taxpayer, the point of using the treaty is to get a benefit. Now, I'm just leaving aside the information exchange, but understand that. That's the idea. The tax treaty is to give taxpayers benefits. So once you say that Article 245 GAAR applies to treaties, what you're saying is, okay, everybody who's using a treaty is getting a benefit. So are they avoiding? That's also okay. But are they abusively avoiding tax by using the treaty? GAAR would apply, and judges should step in. That's the rule. Okay, but you would think now we've got this GAAR, and for sure judges will use it. But you'd be wrong. They still debate whether GAAR should apply, and they still debate what it means to be abusive. That just isn't answered. There probably is no answer. All right, so I just want to call your attention. Don't you love this slide? It just has so many words on it. It says it's Canada's transfer pricing anti-avoidance rule. This is Canada's transfer pricing statute. If you're trying to read this right now, I really commend you. That's really awesome, but it's a lot. It's a lot. Stop trying to read all that. That when people put up their slides and they have just all of these words, I start doing that thing that you were just doing, and then you're not listening to the speaker, because you can't listen and read, so you prefer always reading. I don't know, I'm a nerd, so I always prefer reading, so I start reading the thing and then getting confused. Listen, even if you read it for a couple hours, you're not going to get it. It's a lot. But look at the U.S. rules, so much shorter, so much nicer. Just the secretary can reprice, to prevent evasion or clearly reflect income. And this is an anti-abuse or anti-avoidance rule, a specific anti-avoidance rule. But just, in our defense, Canada has no transfer pricing regulations, and if you've ever read the U.S. transfer pricing regulations, they're a lot longer than our little statute over there. Okay, so we have that long statute, but we have no regulations, which means, we need to have some definitions, first of all. So we go to our definitions. We have an actual section in the Act just called definitions, and everything is alphabetized. It's a little bit of madness because we are also a bilingual jurisdiction, which means the legal definitions in French are in alphabetical order for the words in French, and the legal definitions in English are in alphabetical order in English. And so when you're in the definitions, there's no subsection. So when you go to definitions, you look for the tax benefit. You just have to keep going, page until you get to the word tax benefit. And then if you want to go find the French version, you have to know what the word in French is. And so that's why you see there, it gives you the word at the end. So you could go find it, avantage fiscal for tax benefit. You see that? And so that's our GAAR. So they're saying, you want to know tax benefit? Go back and look at the GAAR. That's GAAR, and the tax benefit in the GAAR goes into the transfer pricing statute. Okay, so you got these bonus rules connecting those statutes. So GAAR and transfer pricing are connected by means of this term, tax benefit. Are you having some fun so far? Are we all having a lot of fun with this extremely doctrinal lecture that never stops?
Lots of fun. Thanks.
Lots of fun. Okay, good. I'm gonna do one more thing, and then I'll see if you got any. I'll test you. I'll give you a pop quiz. Okay, so deciphering the transfer pricing statute. Okay, so just so you know, the way our transfer pricing statute is organized is with this A, C, B, D thing. It's weird. It's like there's an A part that goes with a penalty or the response in C, and then there's this B, bad thing that you do that goes with the penalty or response in D. So it's A, C, B, D. It's weird. It's like, what are they doing here? So I just simplify it. So here's the rule. This is the Canadian transfer pricing rule. if there's a non-arm's length relationship and either the terms of the conditions are not arm's length, or arm's length parties would not have made this arrangement, plus they probably made this arrangement primarily to get a tax benefit. So that's A and B. So terms and conditions aren't arm's length without thinking about your purpose, your motivation, your dreams and aspirations. That's A. Or you wouldn't have made these arrangements if you weren't arm's length and you had that tax benefit motive. Okay, so there you have to primarily want the tax benefit in order to do that. So you see that mens rea element in that second one. So that's B. Okay, so those are the two bad things that can happen. Then a transfer pricing adjustment may be made, but here, note this little wrinkle. So if the only problem here is that your terms and conditions are not arm's length, then what the court is supposed to do, or what the service is supposed to, revenue agency is supposed to do, is revise the terms and conditions to reflect arm's length terms and conditions. Okay, so revise. So that's what the service would do, or the agency would do, and then when a court is looking at this, this is what they would be asking. Oh, is this a case of A, the terms and conditions are not arm's length? Then all you can do, CRA, is revise the terms and conditions. You can't invalidate, you can't say the transaction didn't take place, you can't say the transaction's fake or a sham. You have to just revise the terms and conditions to make them like arm's length. So query, if they're not arm's length, but there is no arm's length, how are you going to do that? That's a challenge for you. Okay, so that's A. But if you've got this second scenario where arm's length parties wouldn't have made the arrangements and they were probably primarily made to get a tax benefit, so both of those things are true, then the agency can change the nature of the transaction or series, to reflect what arm's length parties would do. Can they take the transaction and throw it away and say it didn't happen? No. They can change the nature. I mean, it's kind of impressive that the Canadian Revenue Agency can change the nature of what you did. It's really quite spectacular. Okay, fine. So we get in Agra City a case, if we have time, we'll talk about. We get the tax court confirming that this BD combination, the BD only though, uses the same concepts as GAAR. But the AC, they don't. You don't see anything about tax benefits or primarily or motivation or any of that. So if you're the CRA, you have to think about that we have this funny transfer pricing rule. And if you're going to start impunging people's motivations and saying that they're naughty taxpayers, then you have to go BD. You can't go AC because your AC doesn't have GAAR in it. Okay, so why am I telling you this? Like, who cares? Well, you care because if you're trying to advise clients about transfer pricing, you have sort of two dangers here that are odd and might or might not cause your taxpayer to have to change the way they do things, depending on which way the CRA will view your transaction. So, this is just good to know. I mean, look at that long statute. Nobody wants to read that. So I am just, as a service to all lawyers in the world, giving you the truncated version. Watch out for the AC versus BD scenario, because the BD scenario might potentially get you in a GAAR problem situation. But don't worry, because the courts do not know what to do with this. They do not know how to deal with this. I think that everything that can possibly be messed up in a case gets messed up when you get this transfer pricing GAAR connection going. It's like almost like a formula for a disaster. Like courts are not going to come out on the other side and well, at least maybe I'm too critical. Courts are not going to make any decisions as to which I don't say, oh, that was terrible. I'm going to say, oh, that was terrible to all of their decisions because they mess something up. I'm sorry. That's not very nice of me to say about the esteemed members of our Supreme Court, but there it is, my friends. We have to tell the truth. Okay, so without regulations, Canada's going to follow the OECD guidelines, but we haven't adopted them. So I can't remember if Brazil has explicitly said, yes, great, we love the OECD guidelines, but my guess is no. So you might be in the same situation as Canada on this one, where you see the guidelines, you like look over the horizon, oh look, a bunch of guidelines, hundreds of pages of thoughtful analysis on something we care about, and maybe you're going to go read it if it's going to help you, and if you're the taxpayer, you're going to use it if it helps you, and you're going to completely say nothing, be very quiet about it if it doesn't help you. You'll just go with some different argument, and vice versa for the tax authority. So in Canada, we said in 2012, they're clear, it's very clear, the courts have decided. That's fine, but if you don't legislatively adopt, then they are not controlling. And that's just the way law works, my friends. Here, there, and everywhere. If you do not explicitly adopt something that isn't law, then it's not law. And I don't know, there's still some controversy out there in the world where people think the OECD guidelines and OECD commentaries are law. Okay, I'm just going to have to put my foot down on this one. No, they're not. The OECD is a self-appointed statistics agency with a bunch of bureaucrats who sit around doing stats, and they compare legal regimes and they help their countries by giving them data. At least that's how they were formed. The fact that they've decided to put the crown of tax policy making on their own heads does not make what they do law. Unless you sign a document with the OECD that says you adopt whatever they say as your law, it's not law. So I don't know why courts would ever be confused or taxpayers would ever be confused. I certainly don't understand why academics get confused about this, but they do. Anytime anyone tells you OECD guidelines or commentary or whatever are binding on anyone, you just tell them no because Alice said no. And that won't get you anywhere, but we'll feel better anyway. Okay, so Canadians courts have emphasized taxpayers' commercial law rights and obligations in interpreting the tax treaties. They're less willing to favor arguments about economic substance. They sort of reject them. They kind of stay away from them. A taxpayer, just so you know, a taxpayer that doesn't like a transfer pricing audit, you go I think Yariv said this a little bit about how it worked in the US, the same idea here. You go for an administrative review and you can litigate for the Tax Court of Canada, but you can also, if you have a treaty, you can go through the competent authority process. All right. I'm going to stop, and I'll give some examples if we have time or inclination. But I just want to check in and see how we're doing on this talk so far. So, how are we doing?